Hello, this is Stuart Richland from 420lawoffice.com. I've been a lawyer for 25 years and focusing on medical marijuana law for about 5 years. And today, I'm letting you know about a new assembly bill that was signed by the governor yesterday. It is bill number AB 2650. And it stands for a couple of interesting propositions. On its first reading, you'll determine that, well, this thing talks about allowing for a uniform rule for the state that in general, no medical marijuana co-op, collective, dispensary, or other activity, and it says operator, establishment, or provider, may cultivate or distribute medical marijuana within 600 feet of a radius of a school. So it establishes a statewide sensitive use. Nothing really very shocking there, and it also excludes cities that already have a comprehensive rule in place by 2011, and it applies only to medical marijuana collectives, co-ops, dispensaries, operators, establishments or providers that are authorized by law to possess, cultivate, or distribute, and that have a storefront or mobile retail outlet, which ordinarily requires a local business license. What's interesting about that is that this is the first time under California law that it has been acknowledged absolutely and without question by state law that retail activity is legal. Here in the city of Los Angeles, Judge Chalfant and the city attorneys at various points in our litigation here with the city have tried to suggest that retail sales were not proper. I think it's very obvious that that's contrary to state law, and here you can see that the governor's own law that he just enacted contains within it the implicit position that retail is the activity and retail is appropriate. A couple of other interesting things in here too. The rule attempts to preempt the field, and it goes to support our argument in general that state law provides levels of protection for patients that cannot be derogated from by the cities. There are a bunch of other interesting things in here, one or two of which I'm going to hold back as a surprise for the litigation and to present to the judge for evaluation. But I recommend that you take a look at this new rule and then put your thinking cap on. Assembly Bill 2650, and I'm going to give you a link so that you can see the exact language thereof. All right, so put your thinking caps on. Let's figure out how 2650 can be utilized to further empower medical marijuana here in the state. I think you will agree that there's definitely some gems there to be mined. All right, take good care, and we'll see you soon.
Don't criticize it.